Hi, everybody. My name's John Young from Kingsley Napley in London. I'm joined today by Chris Andres-Pochon from Levenfeld Pearlstein in Chicago. And Chris has very kindly agreed to talk to me about some of the things that a UK business looking to expand in the US by acquiring some US businesses might find it useful to know. In particular, things around differences in the warranty position, things around disclosure practice, use of escrows that are a little bit different perhaps than what you would normally see in the UK. So, Chris, thanks very much for joining me. It's a real pleasure to have you here, and thanks very much for agreeing to talk about this issue.
Oh, not a problem. It's a pleasure to be here.
That's great. So, I think perhaps one of the biggest things or biggest differences between UK and US practice relates to warranty claims and how common warranty claims are in the US and the approaches that are taken to them. So perhaps you could talk to us a little bit about that.
Yeah, absolutely. So warranty claims in the US are much more common than in the UK. Typically, the seller will give a very detailed set of representations and warranties. Representations and warranties basically meaning the same thing in the US context. And those will be qualified by a disclosure schedule, which sets forth exceptions to the seller's representations and warranties. As far as claims go, usually the practice for making an indemnification claim is very specifically spelled out in the purchase agreement, subject to market level caps and deductibles, and so it's a much more common practice to make an indemnification claim in the U.S.
That's really interesting. And in terms of those caps, I think they sit at a lower level than UK caps typically. So what would you expect to see in your practice in terms of warranty protections for sellers?
Yeah, absolutely. So for regular representations and warranties, sort of the non-fundamental ones, you would expect to see a cap of approximately 7 to 10% of the purchase price. And this is in the aggregate for all claims. And then for fundamental representations and warranties, typically you'd expect them to be capped at the purchase price. And fundamental, I mean here, things like the capitalization of the company, ownership, due authorization to enter into the transaction, those sorts of representations and warranties.
That's really interesting. And for the 7 to 8%, is there a kind of commercial practice floor, like a dollar figure, where if it's a relatively small transaction, it will just be a particular dollar figure, or is it 7-8% even if it's a relatively small transaction? So it might be as low as $10,000 or $15,000 in some circumstances.
Yeah, certainly for very small transactions, you'll probably have a minimum cap, just in terms of dollar amounts. I would say for deals that are above 20, 30 million though, you're looking at somewhere between 7 to 10% of the purchase price.
Okay, that's interesting. And you mentioned before you have disclosure schedules, which is rather different from our practice in the UK, where we have a separate document, which is a disclosure letter. Can you talk to us a little bit about the disclosure schedule, what you would expect to see in there, and how that might interact with things like the context of the data room?
Yeah, absolutely. So I think sort of a key distinction between US and UK transactions is typically in the US, the representations and warranties that the seller gives will not be qualified by the entirety of the data room. They will only be qualified by the specific exceptions that are listed in the disclosure schedule. The disclosure schedule is delivered by the sellers in connection with the purchase agreement. It will very specifically state, the reps in section, let's say 312, are qualified by X, Y, and Z, and it'll list out the exceptions. So there aren't really any general disclosures the way that you might have in the UK. there's sort of very specific reps followed by very specific disclosures against them in the schedule.
And in terms of that practice for the specific disclosures, what you would normally see in a disclosure letter in the UK is that it would say that a matter is deemed to be disclosed effectively against all the warranties, even if it's only mentioned in relation to one specific warranty. Although practically we do try and repeat where necessary. Is that the case, or would it be the case for you that if a matter is disclosed against warranty 312 and not disclosed against warranty 5.6, to which it's also relevant, there would be no protection?
It depends on what the purchase agreement says. Generally speaking, if it's silent, then the disclosure would only be against the specific section that it mentioned. But it's common practice in the US to include either in the purchase agreement or in sort of the introductory language to the disclosure schedules, a reference to, if you disclose in one section and it's reasonably apparent on the face of the disclosure that it applies to a different section, then it's deemed disclosed for purposes of that other section as well.
Okay, so that's not entirely dissimilar from the UK, but perhaps a little bit less protective of the seller, which is interesting. And in terms of sellers being able to protect themselves against claims, something that we do see in the UK more commonly these days, although it's still relatively rare, is warranty and indemnity insurance. Is that something which is common in the US as well?
Yeah, very much so, and increasingly common in the US.
That's great. And very interesting to know that warranty and indemnity insurance is common in the US. What kind of premiums do you see, and who would pay for that policy normally?
Yeah, great question. So the premiums have been coming down significantly in the past year and a half or so in the US, generally reflecting a lower level of M&A activity, which makes it obviously a more competitive marketplace for insurers. So we've been seeing premiums as low as 2.5% of the total amount insured, or 2.5% of the policy limit, in other words, and as high as around 5%. So somewhere in that range is pretty typical.
Okay, so that's more expensive than the policies tend to be in the UK, but I guess that probably reflects the warranty claims themselves being more common, so there's a bit more risk for the insurers.
Yeah, I would imagine so.
I guess from a buyer perspective, obviously they will be quite keen to make sure they don't have to go chasing sellers for money if there is an issue, and that they have some protection. Something we used to see in the UK, but which is less common now for a number of reasons, is escrow arrangements. But I think that those may still be quite common in the US. Is that correct?
Yeah, very common, unless the seller is sort of a well-capitalized, going concern that has obvious ability to meet its indemnification obligations under the agreement, as well as its sort of post-closing purchase price adjustment obligations. Typically, you'll see an escrow. Escrows are fairly easy to set up in the US, unlike the UK. So you'll see an escrow for the post-closing purchase price true-up amount, and to the extent that there are indemnities, that aren't covered by representation and warranty insurance, you'll often see a portion of the purchase price held back in escrow to cover those amounts as well.
And is there any kind of market practice around what proportion of the price that might be, or is it something that's just negotiated on a deal-by-deal basis?
For the purchase price adjustment, it really depends on the sort of fluctuation that you see month to month in the target entity's financial statements, obviously. But for the indemnity, I would say market practice is fairly common to have the escrow be tied to the indemnification limit for non-fundamental reps. So like I said, 7 to 10%, sometimes lower.
Yeah, and that will be held for presumably then kind of roughly the period of time that the non-fundamental, non-tax reps run for.
Yeah, that's exactly right. Sometimes you'll see after half of the the survival period for non-fundamental representations has expired, you'll release half the escrow, and then the remaining half gets released at the end of the survival period, just under the theory that it's less likely to make claims after a certain amount of time has elapsed.
Yeah, absolutely. I think it's always, once you've got through an accounting period or so, then things should really have revealed themselves as a rule, once the buyer's been in the business for a while. That's really interesting. Perhaps we can move on to talk about another couple of issues. One is knowledge qualifiers on warranties. We quite often see in the UK warranties qualified by reference to the awareness of sellers. Is that something which is also common in the US?
Yeah, for certain representations and warranties, it's fairly common to have knowledge qualifiers, seller knowledge qualifiers. Those will typically be limited to sort of 2-3 core deal team members on the sell side who have the most knowledge of the transaction, and then it's negotiated typically whether that involves a duty of inquiry, that they have to inquire of their direct reports and their employees, or whether it's just their actual knowledge with no duty of inquiry.
Interesting. And I guess the other thing that is possibly worth considering around claims before we move on to other issues in the document is buyer knowledge outside of the disclosure process and whether or not that can prevent a buyer bringing claims. I think that tends to vary by state in the US. Is that correct?
That's absolutely right. Yeah. So this is what's commonly referred to in the US as sandbagging, where the buyer knows of a breach of a seller rep or warranty. And then the question is whether the buyer can bring a claim based on that breach, even though the buyer had knowledge. As you said, it varies from jurisdiction to jurisdiction. The most commonly used jurisdiction in the US, as you probably know, is Delaware for corporate and M&A matters. Delaware is what's known as a pro-sandbagging state, which means the default rule is that even if the buyer has knowledge of a breach prior to closing, it can still bring an indemnification claim against the seller based on that breach. Now, I said that's the default rule. Obviously, if the parties have contrary language in the purchase agreement, then that language governs. Other states, are a combination of pro-sandbagging and anti-sandbagging. Really just depends on the jurisdiction.
Excellent. That's interesting. Interesting illustration of the difference in state law that you wouldn't really get in the UK, where we're much more kind of one jurisdiction, although we do have a couple of different parliaments producing different laws. These kind of things tend to end up aligned. That's great. Moving on to a couple of other questions. Practice around gaps between exchanges and completions and conditions to completion can be, or closing, as you would say, can be quite different in the US, I think. How does it work when it comes to repeating warranties if there is a gap between exchange and completion typically?
Yeah, so typically all of the reps and warranties of both the buyer and the seller will be repeated at closing as though they were made at closing, as opposed to making them on as of the signing date. That the distinction though is when you repeat those reps and warranties at closing, generally they will be qualified by some sort of materiality standard, whether that's just they're true and correct in all material respects, or they're true and correct except as would not have a material adverse effect. So there is sort of a slight distinction between the reps as they're made at the signing versus when they're brought down or repeated at closing.
It's interesting. And if there is a significant issue that arises between exchange and completion, what would normally happen in the transaction?
Yeah, so as I understand it, in the UK, it's much more common to have sort of a follow-up disclosure where the sellers can disclose issues that have come up between signing and closing. Much less common in the US to have that sort of thing. Basically, if something arises between signing and closing that would constitute a breach, and it doesn't trigger the bring down, meaning that it wouldn't constitute a breach that would make the reps not true and correct in, let's say, all material respects, or maybe there's an MAE qualifier. But if that isn't triggered, then the buyer still has to go through with the deal.
Okay, so that's good to know. And the other thing which I think you have in the US, which is uncommon in the UK, is closing conditions or around financing, and what happens if finance isn't provided by a third-party lender or other funder. Perhaps you could tell us a little bit about how that works.
Yeah, so typically, when you have especially a private equity buyer that's relying on outside funding to fund the transaction, you will have the lender will deliver a debt commitment letter, essentially saying it will make the financing available at closing, subject to X, Y, and Z terms. And then as a seller, obviously, you don't want the closing to be contingent upon the buyer obtaining financing. So you don't want a closing condition for the financing. But if the buyer doesn't show up with the money at closing, because the financing has fallen through, then you'll need some, it's customary to have some sort of recourse via a break fee. In other words, a set amount that the buyer would pay as sort of a penalty for failing to close the transaction after all of the closing conditions have been met.
I'm sure those fees are really negotiated, but how is there like a market practice around that? Is it around just like costs of the transaction that the seller would have incurred? Is it more of a adding on something for their wasted time, or is it a relatively big penalty to just be dissuasive?
It's very much the latter. It's very much a penalty, and it's not necessarily tied to what the seller's transaction expenses have been up to that point. It's usually tied to a percentage of the purchase price, and it's meant to dissuade buyers from treating the deal as sort of an option agreement.
So that would be like 10-15% of the purchase price, something like that, or?
I think it would typically be somewhere around 3 to 5% of the purchase price.
Yeah. Interesting. Something else which might be an interesting thing to bear in mind for people who've bought companies in the UK before, but not in the US, is that it's much easier to have continued employment of sellers as part of the earnout conditions, as I understand it. Is that correct?
Yeah, easier to some extent. You do see earnout conditions in the US tied to the seller's continued employment in some cases. The issue is, as I know is similar in the UK, that you want to avoid the earnout being treated as ordinary income to the sellers. So you do need a pretty detailed tax analysis in the US to make sure that if that earnout is conditioned on continued employment, that won't trigger ordinary income taxation, and the sellers will still get capital gains treatment on the earnout amount.
So as ever with these things, best to bring the tax team in at an early stage, I guess, and make sure that they're happy with what you're proposing before you've spent too much time writing it down.
Yeah, absolutely.
That's great. And I think possibly the last thing to discuss is transaction taxes. In the UK, obviously, when we are looking to acquire shares in a company, we have to pay stamp duty, unless one of a very limited number of exemptions applies. Are there similar transaction taxes in the States? Obviously, it will vary by jurisdiction, but kind of as a rule.
Yeah, generally there isn't an equivalent to sort of the stamp duty. When you transfer real estate in an asset sale, there will be usually transfer taxes depending on the state where the real estate is located. In some cases, that the transfer taxes may apply to property other than real property, but that's really a asset sales specific issue.
Yeah, so not something you have to worry about if you're acquiring shares.
Exactly.
Which is good to know. Chris, thanks very much. That was really interesting and I think helpful summary of some of the differences between UK and US practice and things that people should bear in mind if they're negotiating an acquisition of a US company. Again, I really appreciate you taking the time to talk to us today. It's been a real pleasure. Thank you very much.
Thank you.
And obviously, if you would like to talk to either Chris or I about any of the issues which have been raised in this video, or if you're thinking about acquiring a company in the UK or the US, please don't hesitate to get in touch with us. We'd be delighted to have a chat with you and see if we can help.